Have you ever wondered, if I've been disinherited, do I still have the right to see the trust or to challenge it? If you've been cut out of a will or trust and you're getting the cold shoulder from the trustee, maybe even complete silence, you're not alone. But a recent case, Hamlin v. Jendayi, could be a game changer for anyone looking for answers, or at the very least, another arrow in your quiver. Today, we'll dive into the legal principles behind the case, its implications for trust challenges, and what it means for trustees and natural heirs alike. If you're ready to find out what this law says about your rights, even when someone tried to disinherit you, keep watching. This case begins with Dr. Laura Dean Head, a college professor who passed away in 2013. She didn't have children, but was survived by two sisters, her natural heirs. Now, under California law, those sisters would have inherited her estate had Dr. Head not executed any estate planning documents. But, as you've probably guessed by now, that's not what happened. 2 weeks before her death, while she was gravely ill and under the care of a former student, Jendayi, Dr. Head signed a trust disinheriting her sisters entirely, naming Jendayi as the sole beneficiary. Jendayi argued that the sisters had no right to challenge the trust because they weren't beneficiaries. The trial court, however, disagreed, and so did the Court of Appeals. The court found that Dr. Head's sisters had standing as intestate heirs, the legal term for those who would inherit under the law of intestacy if no will or trust existed. Think of this as your heirs by default. In plain English, even though the sisters were disinherited, they were still entitled to a copy of the trust and the right to challenge it. To clarify, this doesn't mean that anyone remotely related to Dr. Head has the right to challenge her trust, only those who would have an interest in her estate otherwise. In our example, if one of the challenging sisters had children of her own, then those children, the niece or nephew of Dr. Head, would not have the right to challenge Dr. Head's trust, as they would not have an interest in it, seeing as how they wouldn't receive anything from Dr. Head's estate anyway. However, if their mother, the sister of Dr. Head, had died at any point, then that niece or nephew would become an intestate heir of Dr. Head and therefore have an interest in Dr. Head's estate, and thus have standing to challenge the trust. So what can we pull from this? The Hamlin decision underscores two critical points. The first is that natural heirs have rights. Under California Probate Code Section 16061.7, trustees are required to notify not only beneficiaries but also the natural heirs of the deceased when a trust becomes irrevocable due to the settlor's death. This notification must include the terms of the trust and inform the heirs of the right to contest it. The probate code actually provides you with some of the exact wording that must be present and also specifies the font size. So next time you're having trouble sleeping, you should read section 16061.7. Riveting stuff. But why does this matter? Well, because the court rejected Jendayi's argument that only trustees and named beneficiaries could contest a trust. The law recognizes that heirs who are disinherited might still have valid claims, like undue influence, hint hint, fraud, or lack of capacity. And the second key point is that undue influence will not be tolerated. The court found that Jendayi had exerted undue influence over Dr. Head during her final months. Dr. Head was terminally ill, vulnerable, and entirely dependent upon Jendayi for care. By isolating Dr. Head from her family and taking control of her estate planning process, Jendayi set herself up as the sole beneficiary of significant assets, including a $750,000 home. Now, let's talk to the trustees out there. If you're administering a trust, don't try to play hide and seek with the natural heirs, even if they're not named as beneficiaries. Your duty is to notify them when the trust becomes irrevocable and provide a copy of the trust if they request it. Failure to do this can expose you to legal challenges and potential personal liability. And let's be honest, even if an heir is estranged, difficult, or just frankly an asshole, they still have rights under the law. Don't let your personal feelings override your legal duties. If you're a natural heir who's been disinherited, here's the good news. You're entitled to transparency. California law ensures that natural heirs are notified of a trust's existence and terms so they can evaluate whether to challenge it. Did the decedent have capacity when they signed the trust? Was there undue influence with someone close to them, like a caregiver? And were the trust terms suspiciously altered in their final days? These are valid questions, and the law gives you the tools to get answers. The Hamlin v. Jendayi case sends a clear message. The law isn't going to let you hide from interested parties. Trustees must provide notice and transparency, and disinherited heirs still have the right to challenge a trust if there's evidence of wrongdoing. At the end of the day, trust disputes are about fairness. If someone manipulates a vulnerable person into changing their estate plan, the law provides a way to set things right. And if you're on the receiving end of silence or stonewalling from a trustee, cases like this one show that you do have options. So, can you see the trust if you've been disinherited? In many cases, the answer is yes. And if you think something isn't right, the courts may agree. Let me know what you think in the comments. Should disinherited heirs have the right to challenge a trust, or should trustees be allowed to keep things under wraps? And don't forget to like, subscribe, share the video with that trustee that's been stonewalling you. Thank you for watching. I'm attorney Andrew Bethel, and I'll see you at our next meeting.